Thank you, Madam Chairman. I would like to thank you and Ranking Member Berman for your willingness to work to incorporate these three amendments into the legislation. Madam Chairman, all three are aimed at achieving the same result, identifying the companies that continue to support the Iranian regime's illicit quest for nuclear weapons. Current law states that investigations into possible sanctions must begin upon the receipt of credible evidence. The Iran Threat Reduction Act aims to define what constitutes this credible information. My amendment will add to the list of credible evidence reports published by State and local governments. Madam Chairman, you and I are privileged to represent the State of Florida, a State that in 2007 became the first State in the country to divest its pension funds from companies supporting the Iranian regime's nuclear weapons program. In authoring the Protecting Florida's Investment Act, we went to great lengths to create a detailed process for identifying those companies doing business in Iran. As a result, the State Board of Administration in Florida publishes a quarterly report, which I have here, that is comprised of data from 4 external research providers, NGOs, Federal Government reports, company disclosures, and SEC filings, investor relation websites, and industry publications. Additionally, the State Board engages directly with the companies, requesting specific information about activities in Iran and tracks such correspondence in its report. At the publishing of its last report, on September the 20th, the Florida State Board of Administration had reviewed over 400 companies and affiliates. Madam Chairman, I ask unanimous consent to have the Florida quarterly report placed in the record. Florida is not the only State government committed to preventing a nuclear-armed Iran. There are nearly 20 other States with Iran divestment laws and countless municipalities. If a company appears on reports published by these State and local governments, particularly given the detailed process used to identify those companies and maintain an up-to-date list of scrutinized companies, the Administration must take it seriously and must immediately commence an investigation. This amendment will ensure that these reports are considered credible evidence to trigger that investigation into possible violations of U.S. sanctions law. Also included, Madam Chairman, in the amendment package is a 180-day deadline for those companies on which the imposition of sanctions has already been waived pursuant to the special rule. In the fall of 2010, 5 companies were subject to the special rule: Total, Statoil, Eni, Royal Dutch Shell, and Inpex. This amendment will ensure that those companies have fulfilled their obligations to terminate business in Iran. It is well known that the Iranian energy sector is the main source of funding for the regime's nuclear weapons program. These companies must not prolong any technological services that assist the regime in the production of its financial lifeline, oil. And lastly, Madam Chairman, the adoption of this package will require that the name of any company on which the President has chosen to waive the imposition of sanctions in the interest of national security, that name be made public. The world must know that the U.S. is serious about using economic sanctions to prevent a nuclear-armed Iran. By simply publishing just the name of the company, we put others on notice all around the world that the U.S. is watching, we are investigating, and we are taking our responsibility in the international community seriously. Madam Chairman, I would again like to thank you and Ranking Member Berman for moving forward with this vital piece of legislation that reaffirms the United States' commitment to preventing a nuclear-armed Iran, and I yield back the balance of my time.
Thank you so much.